Welcome to This Explainer. Today we're diving straight into a really fascinating constitutional clash. It's a case that basically tests the absolute limits between government power and your fundamental right to just be left alone. We'll be looking at a landmark ruling from the Constitutional Court of South Africa that wrestles with the tension pretty much every modern democracy has to face. Exactly how far can the state go to protect public health before it completely invades your private life?
So, let's kick things off with a pretty wild question. Picture this. You're just sitting in your living room, minding your own business, and suddenly, government inspectors demand entry to search your personal documents and private spaces. No warrant from a judge, no police. They just want in, simply because you might have some everyday over-the-counter medicine in your bathroom cabinet. Sounds extreme, right? Well, believe it or not, this exact legal loophole was at the very center of a monumental 1998 case, Mistry versus the Interim National Medical and Dental Council.
Okay, let's get right into Section 1, the warrantless raid and Dr. Mistry's case.
So, this whole thing kicks off with a private doctor named Ashok Rama Mistry. It started as a pretty standard, run-of-the-mill complaint. A patient alleged that Dr. Mistry was fraudulently claiming reimbursements from a medical aid fund for services he never actually provided. But things escalated rapidly. In response to this single complaint, 3 government inspectors showed up at his surgery. And here's the kicker. They did not have a search warrant. They just entered the premises while he wasn't even there, completely rifled through his records, and ended up seizing patient files and a Schedule IV substance called Persivit, which is a restricted skin lightening cream.
Which brings us to Section 2, the challenged law, specifically Section 28(1).
Dr. Mistry obviously fought back, arguing this sudden raid was completely unconstitutional. And when you look at the law they used, Section 28(1) of the Medicines and Related Substances Control Act, you can totally see why. This law was incredibly broad. It allowed inspectors to enter essentially anywhere, any premises, place, vehicle, vessel, aircraft, at any reasonable time. The only condition? That they suspected a medicine or scheduled substance was on site. Once inside, they had carte blanche to inspect records and seize anything they wanted, all without a judge's permission.
So, what we have here is a massive collision. On one side, you've got these completely unchecked administrative search powers. And on the other side, Section 13 of South Africa's interim constitution. This is the section that explicitly guarantees personal privacy, including the right not to be subjected to random searches of your home or property. Dr. Mistry's argument was simple. The sweeping powers of the Medicines Act completely trampled over his constitutional guarantee to privacy.
Moving on to Section 3, the privacy continuum, pitting the inner sanctum against public spaces.
To untangle this mess, the Constitutional Court introduced a really helpful concept called the inner sanctum. Think of it as the absolute, highly protected core of your private life. The court acknowledged that, sure, privacy isn't absolute, but the core of who you are, your family life, your home, that is sacred. It's the space where government intrusion is tolerated the absolute least. But as you move outward from that core into broader society, your expectation of privacy naturally starts to shift. The court basically said, look, privacy isn't just an on-off switch, it's a continuum. At home, in your inner sanctum, your expectation of privacy is huge. But as you step into a heavily regulated business space, like a commercial pharmacy or a medical surgery, that expectation shrinks. Health professionals are licensed to handle dangerous substances, right? So they have to expect some level of state monitoring. A regulatory inspection of a pharmacy just doesn't carry the same weight as a police raid on a family living room.
Justice Sachs actually wrote the opinion for the Constitutional Court here, and he really hit the nail on the head regarding the historical danger of all this. He noted that uncontrolled search and seizure is a classic weapon of arbitrary governments. South Africa had a very painful memory of systematized, egregious privacy violations under its TAST regime, where state officials could just raid homes whenever they felt like it. The court made it clear, safeguards against warrantless entries are exactly what separate a true constitutional democracy from a police state.
That takes us to Section 4, the constitutional clash and balancing these interests. So how exactly does a court formally balance the government's very real duty to protect public health against our constitutional right to privacy? Well, they used a step-by-step proportionality test. It's like a balancing act. They recognize that the Medicines Act is doing important work. We definitely need to protect citizens from bad pharmaceuticals and dangerous poisons. Regulating modern medicine is vital. But the real question was, did this specific law go way too far to achieve that goal? Could they ensure public safety without causing so much damage to personal privacy?
And here is exactly where the law failed that test. It was just so vastly disproportionate. Technically speaking, this law was so broad that it authorized state agents to raid your private living room just because you might have a bottle of cough syrup.
The Act's definition of medicine covered everyday items found in almost every single home. And because it allowed inspectors to enter any place without a warrant, it gave them a free pass to invade the inner sanctum of everyday citizens. The court pointed out a massive inconsistency. If highly trained police officers need a judge's warrant to search a private home, untrained medical inspectors absolutely shouldn't have unrestricted access.
All right, Section 5, the final verdict in striking down the law.
So, faced with this massive legislative overreach, what did the Constitutional Court do? They completely struck down Section 28(1). They declared it entirely invalid, which was a huge victory for civil liberties. The state's lawyers actually tried to argue that the court should just subtly tweak the law, maybe read it down so it only applied to medical professionals. But the court said no way. The language was way too explicitly broad to just rewrite from the bench. As a result, the sweeping power of warrantless entry under this specific section was officially ruled unconstitutional.
But wait, Section 6, a surprising twist involving Section 98(6).
Now remember Dr. Mistry and that seized skin lightening cream? Well, the court had a tricky situation on its hands. They explained that while the law itself was unconstitutional, going back and invalidating every single past medical inspection would cause absolute chaos for public health. Under Section 98(6) of the Interim Constitution, the court had the power to decide if the ruling applied retroactively. If they invalidated everything done under the law in the past, they'd be inviting countless lawsuits, completely undermining good government and straining the public health system.
So we end up with this classic Pyrrhic victory. Dr. Mistry won this monumental constitutional battle, but the court refused to actually return his seized items. Because the inspectors had acted in good faith under the rules that existed at the time of the raid, the court wouldn't retroactively invalidate his specific search. So he won the war by getting the law struck down for the future, but he lost the immediate battle. The inspectors truly believed they were acting lawfully when they seized his documents and cream, so Dr. Mistry never got his property back.
Which brings us to a pretty tough question to wrap up this explainer. If you can win a landmark constitutional battle, prove a law is invalid, and still not get your illegally seized property back, where exactly do we draw the line between public safety and personal freedom? This case is a fascinating reminder that while constitutions are incredible shields for our privacy, the practical reality of governing and correcting past mistakes is super messy. In this ongoing dance between the state's duty to protect us and our right to just be left alone, the lines are always shifting. And sometimes, even when you win, you don't get your stuff back. Thanks for joining us for this explainer. We'll see you next time.